So on the spot, you get a test right there. That test is not admissible in court, but what that test is a alcohol sensor test that they look at to see if you are intoxicated. Then they read you your rights of taking the test, which is usually another breathalyzer test at the police station. They could take your blood also. Should you take that breathalyzer test if you're in the police station? It's a very difficult question, and I'm going to talk to you about the pros and cons of taking that test. The district attorney's offices have made a pretty hardline policy that if you refuse, they're not going to offer any reduction to the lower class of DWAI. Remember, DWI is a misdemeanor. It's a misdemeanor. It's fingerprintable. You then, if you're ever asked on any applications, have you been convicted of a crime? The answer is yes. If you're convicted of DWI 1192 subdivision 2 or 1192 subdivision 3, 1192 subdivision 2 or 1192 subdivision 3 of the New York State Vehicle and Traffic Law, on any application, you're going to have to put down, yes, I've been convicted of a crime. A criminal offense on a DWI, first-time offender, would carry with it a revocation for 6 months. It would carry with it a penalty, fines that the judge can impose, and again, those fines could be up to $1,400. It carries with it conditions. The Mothers Against Drunk Driving program, you must go to that program. You must go to a DDP program, which is a 7-week course of going to programs run by the Department of Motor Vehicles. Those are mandatory New York State requirements. The Mothers Against Drunk Driving requirement is a one-time program. So if you're convicted, if you had taken the test on the at the police station, if you've taken the test at the police station, you get a breath alcohol reading. If that breath alcohol reading is higher than 0.08, and let's say if you take the test and the test reading is a 0.13, a 0.14, you have a shot and a chance of getting it reduced to a DWAI, which is a violation. And that's what the goal of an attorney would be. Now, certain higher readings than that, if you double the limit, the alcohol limit, it's very unlikely, even if it's your first time offense, that you're going to get it reduced to a violation. But of course, knowing the reading, going to an OASIS provider, going to someone who can evaluate you and perhaps give a course of treatment for you may give you a chance of getting it reduced. If you don't take the test, then you are faced with the possibility of going to a trial on the case, and certainly a trial fee is more expensive than a non-trial fee. But sometimes you have a good chance of winning that case on the refusal by going to trial on the case, because without the actual reading, there are ways that you can try to show that you were not intoxicated, but rather impaired. With a conviction for a misdemeanor, there is a significant chance that you may have to have an ignition interlock device in your car. An ignition interlock device is a device that's put in your car while you're driving, and then sometimes it's very awkward because you have to blow into that device. Having a good experienced attorney, you may be able to not have to have that device as part of your sentence on a misdemeanor.